So, thank you all for joining. We have a really great panel here today. We are recording, so we're going to be posting this online afterwards. So, full openness here. None of the folks here are speaking for their firms. We are not giving legal advice. Any other things we need to make sure?
Is this being recorded?
Yes.
Yeah, the fact that we're not giving legal advice.
Yes.
Yes. So, I'll make sure, and everybody here will get to introduce themselves. We've got a list of questions that we're going to want to go through. At the end, we're going to have open questions, so please do just hold your questions till the end after the discussion, and then we'll have a great time and hopefully learn some new things, right? So our legal panel today is some really great folks here. So I'm going to let everybody make their own introductions. Maybe we'll start here with that.
Hi, I'm Evan Jensen. Some of you guys have seen me around before. I've been here going to these Ethereum meetups for a while. I've talked to you guys at great length about your projects and about decentralization in general. I think this is a huge step forward in various areas, including finance, the economy, sharing, information, intellectual property, and a lot of other ways. And I really think that it's important that we do this right, that there's a lot of tendency to be really enthusiastic and energetic and want to push forward and build stuff, and we need to take a step back and go like, okay, we need to actually comply with the current regime of what's allowed. We need to consider the possible negative consequences of what we might be doing. We need to see 3 moves ahead and build it right the first time. Either do it right or you do it twice. That's my thought.
Hi, I'm Eugenie Rivers. I'm a securities attorney. Was a banker in the previous iteration in undergrads in economics, money, and banking. So I have been interested in international monetary flows my whole life. And I find this whole, Evan introduced me to this topic at a seminar of mine that he came to see. And I'm just thrilled to be here and to be learning about this. I was interested with Bitcoin, but I didn't dive into it till now. So this is great. Thanks for having me. And again, I would bring a traditional securities concept looking at it, but I'm just old enough to remember being shown handwritten ledgers in the bank. So I didn't, there were dead terminals when I started. They were doing, Fortran I think was like cutting edge stuff at that point. So, but you know, watching how this is evolving is fascinating. I think it's just the next generation. It's interesting to see what happens.
Hi, David Otto. I run the law firm Martin Davis. I also have a private equity firm, Otto Capital. We look at emerging growth companies and technologies. So we're opportunistic. I was one of the founding members of a company called Bitcopia. Well, everybody's used it. It's a Bitcoin exchange, and we were around probably 3 years ago, a little early. We got shut down. Some of our guys decided it was probably more appropriate to do this business offshore, and they left. I'm not even sure if we're still open, but at the time we were having a number of issues with respect to regulatory hurdles, as everyone was who was in the business 2.5, 3 years ago, very early. It still is early. Anyway, so I've been around it. I'm interested in it, and I think it's to echo earlier sentence. I think it's both the digital currency space and the smart contract space is it's in some ways a natural evolution, and in some ways so foreign to traditional legal concepts that there's a lot to be done to make this smooth and make it coherent for both people that are buyers at the outside and people that are creators or miners. So I'm looking forward to tonight. Thanks for the invitation.
Hi, so I'm Dax Hansen. I'm a partner at Perkins Coie, downtown Seattle. I'm a technology lawyer. Which really means I do a lot of internet, wireless, software, hardware-related work. And I've also done a lot of video game work and social media work. And so in 2011, when Bitcoin and XRP kind of popped on scene, people were actually doing something with it more than the very earliest adopters. Some of those early pioneers called me and asked, what is this? Is this like a virtual currency? How is FinTech going to regulate it? Is it a currency? Is it a commodity? What is it? How do I stay out of trouble? And so really since 2011, we jumped in and started doing this work in earnest. And there were some wild days there, where people were getting subpoenas, people getting arrested. There are just a lot of questions on how to roll these products and services out. By 2013, it was apparent that this wasn't the same thing. The decentralized currencies, distributed currencies, weren't the same thing as it's another financial service fintech innovation, which I've dealt with for my entire career at Perkins Coie. And so we stood up a new industry practice group, the first one in the world, in fact, a law firm focused on decentralized virtual currencies and blockchain technologies. And over time, out of necessity, we pulled in from our 1,000+ lawyers, 40 or so lawyers who are in different areas of expertise. To get started out, first you needed to know, is this money transmission, is it anti-money laundering? And then it was, you need your white-collar crime people to keep them out of jail, right? And then you needed to, the Federal Election Commission asked, can you accept Bitcoin for donations? You need your political law people. And then the IRS came up with their tax rules, and so you had to go deal with that. So over time, we've added in lots of our different subject matter experts, and we have a industry practice group where we have weekly calls with our team and a lot of data sharing to figure out just how to address this. And frankly, lawyers are just trying to catch up, right? I mean, the Bitcoin moves in dog years, and I think Ethereum and decentralized apps moves even faster than that. And often these are being written, these apps and these contracts and things are being written on, it's essentially the equivalent of an online napkin where things are shifting, and you try to analyze the securities law issues. And is this decentralized? Is it tokenized returns, financial returns? Is it tokenized goods and services? What is it? How do you analyze those tough issues? And short answer is there's a lot of law that fits, and there's a lot of law that's to be developed. And we're getting some very specific laws in place right now that really deal with the terminology around decentralization. Like for instance, the Uniform Law Commission is thinking about a new Virtual Currency Business Act, a model act that states can adopt. And we'll see more and more of those. The BIT license is one example, right? The BIT license was tailored to fit a Bitcoin-related or virtual currency-related business. But a lot of other federal laws, securities law, commodities law, tax law, you're having to try to read the law and apply it to something that the writers of the law regulations never entered their mind, right? I mean, and that usually happens with technology, but here it's a paradigm shift. The decentralization, it is just mind-blowing for a lot of regulators, law enforcement. There's always been somebody to go to. You think of the PayPal model, right? There's money there. If you want to turn it off, or if there's an OFAC violation, something, you talk to that person and solve the problem. Here, with decentralization, often you don't have one central party, and it's intended to be that. It's intended to be something to open that lots of people can access, so it requires a different paradigm approach. So we've been busy just trying to keep up with these issues and help give good advice on both the product offerings themselves and on the commercial contracting issues and other developments.
My name is Carla Reyes. I'm an associate at Perkins Coie and Dax's group. I've been working with Dax on these issues since about the beginning, 2011, 2012. Over time, not only so I work on all the issues about how the regulations apply, old regulations apply to new technology, and looking at the lag. So over time, though, I've become interested in the way that this technology in particular, and the decentralization, the paradigm shift is going to shake up, or the way I think it's going to shake up the way people think about regulation and regulatory theory in general. And so I'm actually making a career shift to become a law professor, where my research will focus on how decentralized technologies may impact or revolutionize really regulatory theory in general.
Great, thank you guys. In your opinion, cryptocurrencies and things like this in general, are these things and these concepts that attorneys are starting to discuss more and more, or are these still fairly under the radar?
I think that very few attorneys have even heard the word blockchain, and the ones that have heard of it are a little stumped as to what it really, like the true significance of the difference in decentralized technology as opposed to having a trusted middleman that's bigger.
And
Actually,
Agreed.
Evan asked a question at our Securities Law Institute last month that had the word blockchain in
Zero
it,
people
and
heard of it.
And you could have heard a pin drop in the room. There's not a single regulator and only one person in the whole room who he was talking about, except for me, because he's been telling me about it. But it was really quite startling that here we had securities regulators from 5 different states and 3 provinces in Canada, and not one of them
And the
had,
federal government.
and 2 people from the SEC, and nobody knew what he was talking about.
So 2 years ago, the American Bar Association had a meeting on virtual currency. They had a conference, virtual currencies. And then this last, what was it? In the last couple of months, maybe it was in April, they had their second one, which was focused on blockchain. So it's still pretty new. I mean, they have 2 conferences, and even then, I'd say in DC, where you expect there to be regulators and others, I mean, there's still only maybe 50 people in attendance at a national event like that, national conference put on by AG that's promoted all the American Bar Association, so the legal
I think
organization.
where you're most likely to find attorneys who know about this would be in Silicon Valley and in Seattle, the tech hubs of the United States, are where you're most likely to find attorneys who have any idea what you're talking about.
So we've heard the term smart contracts and crypto law. Could you comment, is this an accurate statement? Is there some nuance here that we can pull out, the idea of crypto law, or what that really means? Or is it law at all?
So I think what you're getting at is sort of a theory that has been espoused. We started with Lawrence Lessig with an article, Code is Law, of how code is starting to play an increasingly important role in actually implementing laws. The machine just won't do things that it's not allowed to do, kind of situation.
So, yeah, so there is, starting with Lawrence Lessig, up to, there's a professor out of the University of Maryland who just launched a book called Enforcement by Algorithm, Regulation by Algorithms, and I think there's 2 ways to interpret crypto law or code as law. One is Lawrence Lessig's idea that the code could actually be law in certain circumstances, so cyberspace, in online gaming environment, the laws of the land are input by the code, right? And the idea that there are levels of regulation through the terms, through the code itself, through standards put on top by outside bodies, W3C, right? That each of those act in some way as regulation. But I think crypto law is oftentimes thought of in a different way, a little bit beyond what Lawrence Lessig was originally thinking about, in the sense that it's self-executing, like once it's programmed, it just goes, and unless it's exploited or, but the idea being that it would just go, and maybe you can't stop it, maybe it performs in unpredictable ways, and in so doing, is it creating, as it's going, its own form of law, and if so, what kind of recourse do you have in the judicial system? Yeah, can you take that to a judge? What would the judge do with it? If lawyers don't know what blockchain is, what is a judge going to do with that, right? So I think there are a couple ways people talk about crypto law. And I don't know if accuracy is the right framing, but because I think people have different things they attach to it, right? And both of them are valid, just different theories. And there's a growing body of academics, I should say, looking at it in different circumstances. Regulation by algorithm, the reg tech, Lawrence Lessig's more traditional code architecture issues, and then there is one guy looking at, could you have decentralized judicial processes? Like, could you do the whole thing? Could you do court through the blockchain, essentially? And what would that look like? Dispute mediation through decentralized process.
So one thing I'll note is that Professor Lessig did come and spoke at the blockchain workshops meeting in Sydney last fall. And one of the things he suggested was that people not get too hung up on the idea that smart contracts are going to replace lawyers and replace law and operate, outside of law, but really it still operates within some sort of construct, of a legal construct. So while I see opportunities as lawyers to also take advantage of all the developments using decentralized technologies and blockchain and smart contracts to make transactions more smart and more capable, it still has to exist in some sort of a legal construct where people have to agree that they're going to participate under those terms. Like maybe they agree that, that if code operates a certain way, then you're going to you can accept a limited form of remedies, for instance, right? Or maybe you don't. And so I think there's still a lot of room to figure out what is the right sort of interplay between existing laws and new contracts with this smarter technology that can allow us to do much more with our contracts.
Although and I know we're going to get into this a little bit later with the DAO and the hack, but that the paradigm or the concept that the code is the law, it kind of falls apart when you look at a proposed remedy, right? Because if the remedy is the soft fork or the hard fork, or in particular if it's a hard fork, then it's really not the law at all. It's just that's what it was until somebody figured out a way to screw around with it, and now we've got to stop it. And if that's the case, then what about the people that subscribe prior to understanding that there was this defect in the code? Is that what they bought into? Well, there's an argument that says, yeah, you bought into all of it, whether it's good or bad, because you bought into it, if the code's the law. If they bought into what they thought was the impermeable code, this sort of thing exists, then the code really, and that's not what they received. Not a whole lot different than a defect not being reported in the sale of a home, or a problem in a prospectus, something that was not disclosed and is material to your participation. And so, yeah, I hear it to a degree. I think to the extent we're looking at remedies, and they're actively looked at and considered right now, particularly with respect to DAO. Who knows? In terms of crypto law, the extent to which there is crypto law, to the extent it's just another form of the same principles, similar issues, because you certainly could make the argument when it comes to what's happening on a hacked code.
I think you could definitely have crypto law be developed that would stand in, but what we're seeing right now is that this is actually a really hard problem. It's going to take a long time and a lot of experimentation to actually arrive at. For example, the problem that the DAO experienced is basically embezzlement using another corporation, siphoning funds into a different corporation. It's sort of this has happened before, but the DAO didn't know that this was a threat, that this could happen, and didn't plan for it, and didn't have rules and remedies and all these other problems that have solutions within crypto law that just weren't there at the time, and now we'll add them, and then somebody will find some other way to exploit it, and then you got to fix those too.
This is a problem that's not distinct to this area of the law. The law over centuries has developed with, particularly in our system, to have both the law and equity. And equity was always set up. The equitable courts came with courts of chancery in the English systems that we're under because the law isn't always fair. Things happen under any distinct set of rules that may or may not be the result that any society wants. So as a society, and this has always been one of the philosophical questions with AI. To what degree is AI programmed and it fulfills its mission, but yet we don't like what it does. So as a society, we're always, everything we're talking about, crypto law will be, in my mind, a part of the law, but it's not going to subsume the law. It won't become the law. It can't, because it's going to be part of our societal contract of the world we want to live in, and that's what the law is. It's the water we swim in as a society. And so there will be results where it will be just too egregious, and somebody will say, no, we're not going to uphold this code any more than we'd uphold a contract that's so heinous that as a society we're not willing to support it. So to me, the bigger picture, aside from the development of the body of law evolving around cryptocurrencies and blockchain contracts, it's just this concept there's always going to be at some point, society will say, no, we're not going to accept the results of your contract, and we're going to do something else about it under an equitable principle.
Yeah, well, maybe one last comment. This is a tangible example is that in certain states right now, if you sell somebody a Bitcoin or you buy somebody a Bitcoin, that's not regulated under any law, right? I mean, if you sell a check you sell a gift card, or you accept money and you transfer, like a Western Union or MoneyGram, some other money transmitter, that's regulated. But the way those laws are worded, it talks about payment instruments, it uses terms like issuance, or it's a paper, it's paper, or it's tied back to money, U.S. money, which is not just monetary value, but the official form of paper or coin, right? And so today, in some of those states, you can sell Bitcoin and buy Bitcoin, and you don't need a money transfer license, which is an expensive proposition to get one of those licenses. The states aren't, as you can imagine, they're not comfortable with that, because what's really happening if you're using virtual currency, cryptocurrencies as a medium of exchange is you're transferring value. You can take that to a foreign exchange, get money back out for it. It moves very much like money. And so the states are moving to close that gap. They're not entirely sure how. They're wrestling with all these defined terms, and you have to figure it out. But we will get law that has concepts of decentralization and convertibility, and that will be what I think is the crypto law, right? I mean, just like we have developed internet law, we're going to be developing, blockchain law, and we're in the process of that right now.
So let's talk about some regulations, or are there any regulations that currently might apply to some of these technologies, or what does the regulatory climate look like in general?
There are a lot of regulations that currently apply to these technologies, money transmission being one of them. In general, it depends on what the business model is. So just because you're using blockchain, Bitcoin, some other cryptocurrency, doesn't mean you're automatically a money transmitter or a security issuer or any other regulatory scheme, right? It depends. It's all about what you do with it. What's the flow of the technology? For what purpose are you using it? So things we look at are money transmission, securities, commodities. We've looked at, what else do we look at?
Anti-money laundering.
Anti-money laundering, well, I think of that as money transmission, but yes, anti-money laundering. The OFAC regulations apply to anyone, not just because it's blockchain, but because you're in the United States. Taxes, yep. We've looked recently at CFA, so the Computer Fraud and Abuse Act, in the context of decentralized systems that require people to interact with other computers, right, with or without permission. How much was that permission? Are they covered computers under the CFAA? And if not, or if they are and you don't have enough permission and you go get whatever it is off their computer, did you just commit a federal crime? So the answer is yes. There are lots of regulations that apply in this context. And it's all about, in my mind, what you do with the technology, not the technology itself.
Which is an important point, right? I think all of us, lawyers and the developers and other enthusiasts here, need to be making a distinction between these decentralized blockchain technologies as a platform that can enable lots of different business models, like the internet, and offering a regulated or a product or service that should have regulations because they either pose consumer protection risk or some sort of financial risk because you're dealing with money, right?
The FTC Act, so consumer protection. The FTC Act
The
applies.
FTC Act. Right, and so people have to separate out, well, I guess right now as lawmakers and regulators and law enforcement look at this, they bring to it their own understanding, which is many times very sophisticated and sometimes still evolving, and they may have tendency, like some of us, to kind of lump things together, right? Like that it's all regulated this way, right? But if you take Bitcoin, you attach it to a JPEG and you move it around, you're just tracking transfers of title of assets, that should be regulated like movement of money for a payment system.
So here's my concern, is that we've got individuals without a technical understanding writing laws, regulations that close off innovation. So what are you guys doing to talk with technical programmers? Do you guys talk with them?
All the time. I started at my introduction that I'm a technology lawyer, right? I mean, that I'm not an engineer, but we work with the engineers all the time to understand what it is And so, for instance, when the Federal Election Commission was trying to evaluate whether you should accept Bitcoin or not, what year was that? 2013, 2014. It all blends in because we've been doing it, for a while here, back in years. But there was no technical description of how it worked. And so we worked with the Bitcoin Foundation to write a primer. It's on our website, on our blog, our resources page, where we talk about how it works. We worked with the foundation. We've worked with core developers. We go to the blockchain workshops where there's a lot of Ethereum programmers, core developers, Bitcoin as well, consensus folks, and we have these conversations where it's a dialogue between the developers and the practitioners and the legislators and lawmakers and regulators. There's also some industry groups like Coin Center and the Chamber of Digital Commerce, right? These are two industry associations that invite participation by the technical folks. Somebody has to pay a membership fee, but if you are involved in it, you can get your voice heard so that your technical input is registered in things like the Office of Comptroller of Currency's request for comments about innovation, responsible innovation by federal bank regulators, for instance, right? And the Chamber of Digital Commerce wrote some comments in response to that and talked about things like this platform and kind of the technical aspects of it, and invited feedback from their members on this.
And made the point that because regulators don't often understand fully, and because sometimes programmers themselves don't understand fully what shape their stuff is going to take, that maybe sandboxing would be an appropriate way to think about regulation and what might work well for different types of applications, right?
But I want to underscore that it's not easy, right? That anytime you hire a lawyer to help educate law enforcement first, and then a regulator like the SEC or the CFC or somebody else, it's very, very expensive. And a lot of the startups have not had the funding to do that. A lot of those who have raised venture capital funds, their venture capital donors don't want those funds being spent on a bunch of regulatory uses, right? So some companies have gone out of business. Some of them call us, and they call you too, and they say, do I have a big issue here? And you kind of point in the right direction. And as they raise a little bit more capital, then they work on it. But it's because decentralization started with the Bitcoin model, which was a money movement, people automatically fell off this cliff where they had to deal with the very complicated money laundering financial services laws. Whereas if it had been allowed to work on a different use case, it didn't touch money at all, this would have progressed further and not faced as much scrutiny. So it's still a really tough issue, and even the established companies today are still they're kind of cash strapped, trying to figure out how best do I make an impact. Many of them have folks who go and talk a lot. It's an open community. They want to go talk to the regulators, show up at these panels and other things. But it's going to take time. It's taken 5 years plus to get to where we are now, but it's going to take longer before we fully get there. But financial institutions are interested in decentralization right now, and so the SEC, the CFTC, others.
I just met with R3 Monday, last Monday.
With CFTC?
With R3.
With R3, yeah.
So,
Our former colleague, Jacob Farber, is the general counsel of R3. So he left Purpose Creek to go there. So it's people like him and us and you guys who are out there, who understand it, understand the technology. You have to understand the technology first. The technology sells itself. And once you understand it, then you can be an advocate. There's a lot of skepticism. But the reason we're invested in this is because we see that this is fundamental platform technology like the internet, and it's something to be focused on.
David, what was your experience as owning a business or running a business and then having that?
Yeah, well, I was just going to comment. Yeah, the user programmer participation and involvement is critical. A couple of years ago, FinCEN came after us as being an illegal money transmitter and looked to shut us down. We probably spent 6 months working with the regulators there to try to encourage them not to be so heavy-handed. That there was, this was 2.5, 3 years ago, Oh, no. That there's a way to do this without just shutting it down, without just sort of uniformly saying, no, we don't know enough about it, we don't know enough about you. And as a result, we're not allowing this to occur. You cannot operate as a Bitcoin exchange in the state of Washington or any state until we get a better handle on this. We, in fact, went to a friend of mine's at who they represent B of A, they represent Wells, Union Bank, large international banks, and sought their advice and assistance, and if we could get some buy-in at the commercial bank level. Yeah, this is interesting, it has potential, we're a little early, but this isn't the way to look at it, just to shut it down. It moves it offshore, it moves it into other avenues. It's not effective regulation, at least in our view. The banks at that point didn't want any part of it. In fact, they thought we were nuts, that this was a fad, it was going to come and go. I agree with you, Dax, that's not the case now. The banks are very interested. In fact, every big bank does have a digital currency, blockchain sort of thing.
Just an article, the Bank of England's looking at implementing one.
Yeah, exactly. So they're all very interested now. It's a different deal. But part of the dialogue, yeah, I don't write code. I appreciate what it can do. And a number of my friends have been involved in different businesses that are software intensive, and we've invested a lot of money in different software businesses, some of which have failed, others which have done okay. But the effort and dialogue, in my experience, with federal regulators and the state to a degree, to try to educate them on some of the technical pieces in the hope that a sensible law will be crafted out of that. We are some distance away. We are some distance away. Which argues for more vigilance on the creator, the developer side, absolutely, and lawyers. I'm at a handicap. I get the law and I understand the dynamics and the parties, but I'm not deep. I'm not in the code at all. So I wouldn't be the guy to explain the code to the expert that FinCEN brings in to say, okay, let me tell you why this is all not going to fly. So that dynamic is very real, and that was a large part of what we spent a good 6 to 8 months battling, and we didn't win.
And one of the things David brought up is really important. So many of these regulations are two-tiered, federal and state. And so you've got to deal with, we get the job, as a good example, we get the Jobs Act. It says we're going to have crowdfunding. Well, Faith Anderson, who's the executive deputy director of the Washington Securities Division, hates crowdfunding. So what we did in Washington, crowdfunding was that not one company has ever qualified under, because she personally hates it and refuses to implement it until we got federal preemption now. So just as an example, until the federal government says, if it ever does, and it probably will when we're talking about currencies, it's going to have a preemptive effect at some point, and the state won't be able to win. But in the meantime, every single state's regulator is going to be looking at this, trying to wrap their mind around it. And as you pointed out, maybe California, maybe Washington would be on that cutting edge. Hard to say.
I think it needs to be. One of the reasons why is that you've got countries like Singapore that are already making moves. And if this country wants to stay competitive, and they want the talent to stay here, then you need to move.
No question.
No,
That's just reality.
Smaller countries actually might get ahead of us.
Yeah.
Probably will,
They will.
because they're
They are.
much more nimble.
Yeah, over and above the application of the blockchain, a lot of people, in fact, many people doing startups in this room have done a crowd sale where you create a token and intend to sell the token in order to raise money for your startup. And I'd be curious to hear you guys' input on how securities laws and the laws regarding raising money for a venture play into a crypto crowd sale.
What is it?
Yeah, well,
Please. Yeah.
I think you've got all the same securities issues that you have with any securities offering. If it's a token that is going to be sold with an investment return, as the Dow clearly states on its manifesto, it's a security. There's just no two ways about it. So if you want to do a crowdfunding with a cryptocurrency or tokens or anything, you're going to have to play by the rules
But if your token is instead meant to be a way to access storage,
Yes.
to access some services that are available, right, software service or something, then it
It's
can
different
be
story.
that you just use that as another delivery vehicle, where you could have, software key or some way to access the item, right? And so there really is a question.
Yeah.
Is this thing being sold with, you view it from the investor perspective, is the investor buying this with the expectation that they'll get some sort of return based on the efforts of others,
Correct.
right? So if I'm buying this because it's speculative, I think, hey, wow, this is great, someone else is gonna build apps around this and it's gonna grow in value and I'm gonna get some returns, then you are back in that securities analysis. But instead, all you get, I pay money and I get the right, maybe at a discount, access some sort of services, online services, then it's probably not a securities issue. But the short answer is, I haven't seen a crowd sale that's been simple yet, right? And that a lot of these are, they're rushed out the door. And because, back to the comment about startups not having a lot of money to spend on anything, there's constantly legal issues, people kind of skip that where they didn't know to go check, right? And then put your head in the sand. And you don't want to mess with securities violations, right? The SEC has been very active on Bitcoin-related investments, right? Including mining and sales. I mean, there are several cases that are out there that talk about this issue. And people haven't really gotten letter rulings yet on whether a certain type of currency, like Bitcoin, is that a security or not. One of the things we said many years ago is that's what someone should go do, if like to get a no action letter request on Bitcoin, for instance, right? And I think that things have changed, right? Like it's pretty clear that Bitcoin itself right now is more of a currency than a security. But in the early days, it wasn't at all clear because people were buying it as a store of value, as investment, speculative purposes, rather than to use it to buy stuff on overstock, right? And it's still a little bit unclear in that regard. So short answer is you always have to go check, right? You have to go get terms figured out, and lawyers, these kind of lawyers can be your best friends, right? Our goal is to keep you out of jail, out of trouble.
Figure out how
to do it the right way, like how do you get to the green line?
Right.
As opposed to, because if you don't vet it with somebody who's helpful like this, you're going to hear from the enforcement arm of a state or federal regulator, right? Where there's criminal penalties and all sorts of other things. What's that?
The lawyers that are not your best friend.
Yeah, the lawyers are not your best friend, and it's expensive.
That's a different discussion, yeah. And so you take that one step further, the service versus a return, and the service for consideration. And then the service or the ecosystem doesn't quite turn out to be what you thought it was. Somebody can hack it and rip it off. So what do you have now? You have something that you felt was misrepresented to you. It's something that you just didn't know that, you assumed the risk. Now so this goes a little bit further, right? Because if it's an assumption of the risk concept and you're buying a service or you're buying access, but you get to vote when there's a defect. You get to vote on how you correct that defect. That voting concept then moves toward ownership, right? And so you're an owner in what? Well, it's not technically an LLC or an Inc. So it defaults to a GP. Units in general partnerships are securities. If you want to just kind of walk through that, you can get there relatively easily. So that's the legal argument. The economic argument, I think, is somewhat interesting in the sense that so you assume the risk. You buy into a blockchain technology and coin system that turns out to be a defect. What's the remedy? Well, it either gets fixed at a cost to the owners, and and so then the hack becomes really a good thing, because you have disclosed the weakness in the system, and that weakness prevents further corruption, and that weakness has to get fixed anyway, right? So what's the identification of the weakness, or the susceptibility, worth? Well, if you analogize it to airplanes, automobiles, in the law, there's big value. That's real value. Now, you're talking about the difference between saving lives and developing a secure system, and assuming risk or not assuming risk, or participating in that with the exchange of money. But from a legal principle standpoint, there are still some of the legal principles that applies to whether it's security, whether it's currency, whether or not the contract's smart, self-executing or not, can apply to remedies and correcting the problem.
But shouldn't we be saying that, I think that the Dow is premature, right, to be raising that much, to be raising money in the first place, to be raising that much money
Ignoring it.
without,
Evaluation
I
of
mean,
securities laws.
like, we're not even in beta testing,
They weren't
right?
even close.
And so, you're right, that what was the cost of discovering that error? It was $50 million, right? And that could be, you know.
Maybe, right, because they're
Yeah.
negotiating what he's really looking for, they are looking for. But
I think from the standpoint of the question of the securities laws, it's kind of easy to just say the securities laws. Securities laws encompass an enormous number of issues where people can get ripped off. And they've developed since the 30s primarily. So again, they're not terribly responsive even to the internet, much less the kind of technology you guys are talking about. But we have lots of liability. You have the liability of, okay, the GP interest is a security. Should it have been registered as an offer, right? Should they have done that properly? Yeah, but you also have broker-dealer licensing, investment advisor licensing, investment company licensing, transfer agent licensing. You've got a full panoply of these laws that will apply to anybody that participates in the sale, and that's defined by our regulations, in the purchase and sale of something that's deemed a security. And there's huge liability for the individuals. So this is a conversation Evan and I started with, was when it's decentralized, who bears that liability? And where is it going to land? Well, the securities regulators are going to look for a human somewhere in this line. And so at the bottom, you're going to hear this overlay of securities laws on this concept, this democracy of the decentralized system is going to be a real tough fit. And it's going to be very hard for lawyers like us in today's regular environment to give good advice to people, or advice you want to hear. That was the Dow acting as broker-dealer and unregistered portal, crowdfunding portal. I think it probably was. Probably is. You've got you've got the crowdfunding portal licensure also on top of everything else. So the securities law issues permeate every single level of what using blockchain technology to raise money for ventures at every level, from the person that writes the code, which I understand can be more than one person. It's not just one guy writing a contract, so that the SEC can go, okay, well, you were the promoter. That's kind of the problem with answering the question, is that there's a giant regulatory umbrella that will pierce into what you guys are trying to do at any number of levels, some of which we may not anticipate until we watch this play out.
So I think we need to break down some terms of art that people have been throwing around here. A general partnership is one that I think lawyers will be very familiar with, a lot of people are not. There's a bunch of different types of entities people could have: a corporation, an LLC, general partnership, and so on. Corporations enjoy a interesting property called limitation of liability to your investment. So if you buy a bunch of shares, it is impossible for you to lose more than the value of those shares. General partnership, that's not true. You can lose more than you put into the general partnership. You can be personally liable for things that the general partnership did, which is why we get this potential nightmare scenario for distributed autonomous organizations if it's a general partnership, and it seems that unless you pick another entity, it's going to default to being a general partnership, that every single person who buys even one token in this general partnership could be liable for everything that the entire DAO does. I'm not suggesting this is likely, because there's probably going to be things that happen to make that kind of ridiculous outcome not happen. But that is the worst case nightmare scenario that we need to be at the front of the brain here about, like, how do we avoid that?
Well, that you can get there really easily under the law,
Yeah.
right? That everybody is liable. I mean, you hope that's not the case, but you know, you can't find a person behind the curtain.
Yeah, somebody-
So how do you
Well,
say?
hang on, no, we just went through a meltdown in the real estate finance industry in this country, and they have how many banks?
Thank you.
Yeah, exactly, where there was billions of dollars getting sucked out of the system by banks, and every one of these banks is structured as an Inc., an LLC, a limited, a general. And by the way, the general thing is a big stretch when you look at how you constructed GP as opposed to a limited. First of all, well, we can get into that, but everyone who's putting money in has no real idea, at least in my understanding, as to what the purpose is of the entity. I mean, there's a general idea, but there's no particular idea. General partnership, generally people getting together with a concerted purpose, consistent with an objective, buying real estate, developing a strip mall, and stuff like that. But so I
What
think,
about buying into buying tokens for a project?
well,
You're buying that into that project.
and so the question is, what's the project, number one? And the question, I think it goes further. It goes further because the construct, if the construct allows for voting, but you don't vote, haven't had a call to vote, there's been no opportunity for a vote, and there may never be a vote. In theory, and particularly when you start looking at how dominant the code is meant to be in this construct, the code is law, and so there really isn't room for human interface. Then the vote might just be a sham, sort of a useless exercise that really doesn't amount to anything. If it can't be carried out, and if it can be carried out, but it doesn't happen, then what's your value from a general partnership interest? I'm saying I'm just raising issues around a typical construct in a GP or limited partnership. A limited partnership limit the liability of the participants. They are absolutely very different. And so when you take a look at this from the standpoint of going after the people behind it, I think, and it's where we are from a political and regulatory sort of reality. This industry is vulnerable. It isn't as well financed. It isn't as well structured from a lobbying standpoint. It isn't as sort of politically powerful, which is why banks can get away with stealing billions, not trillions of dollars from people who owned homes and lost their homes when the market went down, and no recourse. Oh, by the way, plenty of humans behind those organizations. None of them go to jail. Why? Because the regulatory environment says basically, look, it's hard to say that Mr. Smith or Ms. Jones really knew, had knowledge, or had the intent of creating this consequence. You can say the same thing. You can say the same thing in this environment. There is no way anybody who bought Ethereum or that bought Ether or bought any tokens that you could ascribe that they had knowledge or intent for some negative consequence. At least that.
Meaning the exploitation of vulnerability? I mean, so right,
As an example.
if I'm one of them, I actually kind of hope, so say I bought tokens, I actually kind of hope it's a general partnership, so that the guy who took the tokens and exploited the vulnerability, so I can sue him for breach of his duty of loyalty to the partnership and his other obligations as a partner. And then, being a former litigator, I would name him as a John Doe, and then I would use the civil discovery process
What if he's in
to figure
Bangladesh?
out who he is, and then I get my.
What if he's in Bangladesh?
Yes,
in
then
a hut?
I use the Hague Convention procedures and I go get him. He's not immune
Practically
from my
harder-
service.
Harder to get them.
Yeah, but
But-
not impossible.
Yeah. I mean, comes to the US and grab them.
They regularly sue people in other countries.
In terms of the securities laws, they don't care where you live, they care about protecting US citizens. And so if, you know, they might not be able to extract money from it, but you will stop having any ability to raise money here again. So, you know,
Yeah.
they will prevent you from continuing to participate in any fashion in our regulated system.
So I know Katie wants to move
Yeah.
to other things. I guess the point really here is just that there's a good way to do it and a bad way to do it, right? And I'm all for people trying to do things, but it's worthwhile just asking, is there a better way to protect myself and all the investors? Maybe if you set up as an investment company or a limited liability, if you had some sort of an entity like that, it was clear that all the people who are coming in were
All right.
limited partners.
So I think we've had a good discussion here, and I think we're ready, really ready for questions, right? Okay, so how we're gonna do this, I will call on you. I'm gonna ask your question. Please be respectful and don't try to follow on with your questions, and we're gonna make sure everybody can get their questions in. So thank you very much for our discussion here, and now let's move on to the questions. So Aaron in the back, please go for it.
So I'm really curious about how jurisdiction is handled, and when you're defining things like a general partnership, are there any requirements that was sort of like organized in the US or something like that?
Well, that is a very interesting issue when you've got a decentralized network that extends out of any one country. So it will, I think from a security standpoint, it's going to be looked at from where the investors are that got injured. The general partnership itself is going to be, the jurisdiction will be whoever decides, whatever regulator decides to bring the action. They're going to decide where they can most effectively and under their mandate bring it. If it's the Washington regulator, if there was a Washington person that lost money in the Dow meltdown, the Washington regulator has jurisdiction. So it'll, from the securities law standpoint, it's generally looked at as where the injured investor is. From a general partnership standpoint, it's a more interesting question.
Yeah. So the jurisdiction is a big issue, and it's opaque at best. But back to what we were talking about just briefly. All this underscores is it's a bad idea to have the regulators create the regulations without active, significant input from people that are creating the product, if you will. To the jurisdiction question, yeah, it's a it's solvable, right, by addressing jurisdiction in the context of creating that particular blockchain community. But in the case of the DAO, that didn't happen, so understand.
From a regulator's perspective, we also have seen traditionally international cooperation. So like when Liberty Reserve was enforced against, it was 6 countries, and there were indictments and arrests on the same day in 5 of them, right? So Spain, US, Costa Rica, Portugal, maybe? I forget who the other 2 were, but so yeah, I think you see international cooperation, in particular when jurisdiction is murky.
Yeah.
They're like, we'll just all get involved and we'll do it together, right?
Right?
So is the main reason why this is considered a general partnership as opposed to a limited partnership is because the partners have voting power? Is that generally correct, or is there another reason for why we're considering this a GP over an LP?
A limited partnership is a thing of statute.
Okay.
You have to comply with statutory rules. There's a written agreement, a limited partnership agreement, which everybody signs and says they agree. They're going to put the money in, but they don't have any say. The general partner has all the say. The general partner retains full personal liability. The limited partners enjoy the same status that Evan was describing corporate shareholders were. They can lose their money, but under most circumstances, they wouldn't be liable for the debts of the entity.
So,
But it's a statutory creation, just like a corporation. It doesn't default.
sorry, but all of that, okay, right.
One follow.
But, so I'm still wanted to, so if they do think of this as a contract, and the contract is the code, it is the law, and they're viewing it this way, and they do get into this agreement, and let's say that their operating rights is this, then that, should you say it could still be an LP? I mean, none of this.
Yeah.
Well, if the code meets statutory requirements.
Yes, it will.
Like if all the elements of the statute are written into the code,
Sure.
sure.
Okay.
But I don't know that they are there. I haven't
But isn't, maybe I'm not understanding, but I thought what was really being described is that when a mistake is made in the formation of an entity, or an entity is not formed, that the danger is defaulting into the general partnership.
Correct.
So I don't see how and I don't understand this stuff, I'm not quite sure how a contract could create an LLC, because at some point somebody has to go to the Secretary of State, correct?
They do, and they have to sign something.
Correct.
And they have to sign, and there has to be somebody who steps into the role of organizer, managing partner, something in that. So the danger here, I don't think, is that people went out to create a general partnership. The danger is that by error, they became a general partnership. They took on full liability. And if you remember back long enough, I think, to me, you sometimes think, well, these big things can't fail. Wasn't Anderson a general partnership, and didn't Enron basically take it down?
Enron took.
Enron took Arthur Anderson Consulting down.
And now Accenture.
It was
No, but Anderson was a partnership.
And the Edwards, what was his, what was it, WorldCom?
Yeah, but I mean, there are some big general partnerships out there that have, I mean, we wiped out one of the big 8, and I know it's a long time ago, an old fart, but these things can have huge ramifications. I mean, that was a worldwide partnerships were dissolved. People lost their entire equity and life savings, who were, an Anderson partner in Calgary, Alberta, lost out because of a mistake of Anderson in Houston. So you just don't want to default into this.
But isn't that what you signed up for, though? As part of being the partner?
Just because you never think it's going to.
Right, but still,
Yeah.
ignorance is, I just.
So the question in your world then is somebody buying a token, I mean, presumably somebody decides to be an Anderson partner or a Perkins broker or something, they have some.
No, I don't like that.
Some, more sophisticated understanding of the scope. Somebody buying a Bitcoin, and this kind of one concept in the securities laws is the disclosure idea. The idea that if you're sufficiently sophisticated and you know all the parade of horribles that could happen to this company, you decide to put your money into it anyway, well then you assume the risk. That's your problem. And you were told, and you decided to take that opportunity, assume that risk. You buy a token, you get to read some code. You have to be able to read code in order to understand what your risk is. So,
It did come with, there were terms and conditions in addition, what did they call the terms?
The manifesto.
No, I've just read them, the terms and it said all the terms or all the contract conditions are in the code, see here. But by the way, when you do this, we're just specifically disclaiming all these specific risks. And I thought one of them in particular called out, this is a very new and unique enterprise, and it's vulnerable and bad stuff could happen. So just FYI, if that happens, not our fault, right?
Which was interesting, with those risk factors in the Dow were so they were trying to kind of mirror securities.
Yeah.
But it was interesting, but you really go to, what if the description doesn't match the code? So in the normal securities world, you would have, say it's a derivative, you've got a derivative contract, you've got a description of the derivative contract, the SEC reviews it and decides whether or not the description is accurate. Well, so who's reviewing the code to see if the narrative description is accurately reflected in code?
So under a general partnership like this, would the liability transfer if you sold the tokens, or does it remain with the initial investors?
The general idea is everybody that's that's an owner, the token owner is a partner. You're part of the team. You're on board.
But the securities liability might continue. It depends on the situation.
Yeah, we're made up.
Oh, I was just going to add a statement that the DAO did include a statement on their website, and I don't know the exact wording, but they said, here's the code and here's a description of the code, but if there's a discrepancy, the code is correct.
Yeah, but the question is, from the security standpoint, is that disclosure? Does that actually provide a meaningful enough information that a reasonable investor can make an informed investment decision.
Okay, so-
If you don't understand the code, don't invest, it also said that.
Yeah, I think that was on prospectus. is your-
Right. Well, was your point that if you bought and sold, were you a general partner?
Right.
Yeah.
I mean,
And your liability probably extends to your spread. Make any money?
Yeah.
The solution to this problem is writing so there's a bit of an issue with the terminology being used between the software development side and the legal side of this. A smart contract, what we're calling it a contract, it's not necessarily a contract. If I have a smart contract, it says I'm gonna give you $50, that's not a contract, it's not a reciprocal exchange of promises. So what we need is a new breed of lawyers who are comfortable writing code in order to do things like disclosure requirements or limited partnership requirements, statutory requirements in a smart contract, or write a contract that is both clear to read for somebody who is not a software developer or a lawyer, that nevertheless will execute correctly on the blockchain.
And I completely agree, and in a recent law-reviewed article recently argued that we need regulators who do the same thing. That's good.
Amen.
I just had a kind of a weird thought for you, but sometimes in securities, don't they go to experts and get like an opinion letter that says this is? So is there going to be a market for firms doing these startups around this cyber technology to actually get an opinion letter? Would your firms be interested in actually?
I'm happy to answer that, because what happens
Probably been
practically
asked.
is that in the Silicon Valley in particular, which is where a lot of this development is happening, the banks or the venture capital firms who are making investments in these startups ask that exact request. They say, give us a legal opinion that you're not a money transmitter, you're not violating securities law, whatever it is. Practically, that is not possible for any law firm. No law firm gives an opinion on that. We give opinions on things like doing incorporation or something. In a financing, there are certain very discrete things that the American Bar Association has laid out that we give opinions on that are enforceable by a third party.
Your insurance contract. basically.
But what that really has translated into is, give me a legal analysis. Tell me, am I violating the law, or am I good on it? And that we have been doing for years, and I call it a regulatory roadmap, where we go through, we have all facts, we bounce against all law, we come up with a recommendation, and that's attorney-client privilege. And clients should not share that with the bank, or with their venture capital, somebody to do with their venture capital,
Or their
because they have
investors.
to, or with their friends or their partners. But what they can do then is ask us for another thing, which is now give me a white paper, essentially, tell me what the landscape is on these topics without giving away all the details. It gives somebody enough information to feel comfortable lending to them, or to categorizing them as an MSB or not. And that we do as two separate deliverables.
But this could be a way that the law could evolve. Maybe opinion letter is too strong a term, but
Yeah.
one of the ways the law can evolve is by defining a set of guidance that can be given to startups.
And so FinCEN has been doing that, right? So in 2013, they had their guidance, and then subsequent, and it wasn't terribly clear, right? And so subsequently, folks have been writing in asking for, so am I an administrator? Am I a exchanger? What am I? Am I anything? And then they've been following up with, well, miners are nothing. If all you're doing is designing software, even if it's designed for transferring Bitcoin, then you're probably nothing. Probably being the word that they use, right? And trying to separate it out. So it has been happening in certain contexts. And with certain money transmission regulators as well, we've been successful getting opinion letters in certain contexts.
So that's a different thing, right? I mean, you have law firm opinions, and then you have regulator, like no action letters or interpretive guidance.
Right.
And then there's a third thing, which I think what you're going to, which is as these things get commoditized, right? Is these transactions occur a lot. Can we develop a concept where law firms actually give opinions? Like, for instance, this wallet, this hosted wallet, is set up in a multi-sig arrangement that meets X, Y, and Z requirements, right? Like, there's no way they can do a fraudulent transfer. That, I think we will see ultimately that, right? As you get more standardized transactions, you might hopefully get law firm opinions on that.
So I heard an NPR article last Saturday where because of real estate doesn't require all the KYC that some transactions require, that I forget who brought a lawsuit against an apartment in New York or a piece of property in New York because they didn't know who the owner was. So my question is, since apparently someone can sue an apartment to find out discovery around it or whatever, can you sue a smart contract? Can you sue a Bitcoin address? And what would that mean in the case of the DAO, for example, or another smart contract?
Well, historically, that's interesting. It's called NREM, which is it goes back to, it's INREM. It goes back to ancient English law where the land was a person, was considered a person. You could sue the land and you could sue the name of the land. And so my guess is they brought an NREM action to find out. That would be my guess in real estate law. This is completely, the law, the world in which NREM actions were contemplated doesn't fit this world.
The thing with that though is that in REM you could theory, like the court could theoretically take the land, whereas nobody can take somebody's, Bitcoin or Ether out of the Bitcoin address without the private key. You just can't do it.
I wouldn't go quite that far. I'd say that that's the technical solution. But we have that you can encumber, for instance, with liens, Bitcoin or Ether or anything else, right? You can that can be if someone is exercising their security interest, they can go to court and someone can compel back to your.
Well, if you know who it is, you're right. You can compel.
Well,
but we're talking about all we have is an address, right?
Well, I mean, there's a lot of things coming together at the same point. You have these analytics companies that have all sorts of information about who has.
We still haven't found
what.
Satoshi Nakamoto. Let's say we haven't found Satoshi Nakamoto and everybody's been looking for him. Now, for example, let's say the next DAO, because of the fact that something may happen to these the DAO folks, decide to release the next DAO, DAO 2.0, who is designed to do X, Y, and Z, Nakamoto style. In an unknown fashion, we don't know where it's from, came out of a Tor exit node, that's all we know.
Yeah. Sure, I'm not saying it's easy, but I guess my point is just this, that through analytics and to the fact that people are sharing their addresses for lots of commercial reasons, that we're getting more and more information on the blockchain, right? Where at some point we'll have more information, we always have more than we did before. And so you may have to just file a suit against a particular address. You may not be able to recover it, but at some point you might, right? And so
Yeah, I would
Sort of John Doe.
adhere to the advice of a buddy of mine who's at the U.S. Attorney's Office, Southern District of New York, who said if they want, they can indict a ham sandwich. So, if you think your smart contract is safe, just be careful.
So these smart contracts and cryptocurrencies, they fall into jurisdiction. Is it because eventually they are converted into or to a government currency? What if it was just purely cryptocurrency? Would it still fall within jurisdictions and laws?
Oh, yeah.
yeah, I mean, it does. I mean, a lot of statutes talk about monetary value.
Because there's a human component? That's the only...
No, I'm saying that there's certain statutes that talk about you can't do certain things without a license with monetary value. You can't sell it, you can't buy it.
Monopoly money, the game, right?
Right.
I mean,
There's regulations on that too. There's gift certificate laws.
okay.
Wait, what?
And unclaimed property laws, right? And the short answer is monopoly money doesn't raise any significant issues because it's only got limited use for it, right? Limited use, but once that monopoly, I mean, like if you turn monopoly money into the only currency that you can use to cash out real dollars, right? You're selling that on the street. If there's an exchange for it, it's regulated.
But the monopoly money in the Park Brothers game has no value. When McDonald's makes a game out of it and tokenizes it, then
It has to comply with all
it has
the
to comply with
sweepstakes law.
Yeah, even if it's like 1/1000th of a cent. That's why they have that at the bottom.
And it's taxable, if you think about it. The IRS has said, the IRS will tax barter if they can get their hands on it. The IRS will, has defined Bitcoins as property.
Even if you never convert
Doesn't
to
matter.
piece of property.
There's value. The IRS wants their piece of it.
So it seems like any coder who releases a smart contract, like an arbitrary smart contract, could potentially assume liability for any kind of, this generalized to like every case. So I'm thinking, like, why would, I mean.
This is gonna go underground.
Is there magic terms that you can include in your source code to reduce that liability?
Well, here's a question. I mean, if you've got a smart contract, the question is, well, who are the parties to it, for instance, right? And what does that contract do?
It goes back to that issue we talked about at the very beginning, what is it doing?
Is a smart contract to execute long and short on a stock, right? Then
There's no magic one size fits all.
Right.
You are okay if you do this, but it will depend on what the application is, how it works, what the purpose is.
What are you looking to do with a smart contract?
So even in the case where it's not like a contract, but it's like unidirectional thing, if someone implements it as like an element of a constellation of contracts that happen to be nefarious, then you've assumed responsibility for facilitating that constellation of execution.
maybe gotta look at it. I mean, what I don't want you guys to leave with is that like we're saying, I feel like we're saying, wow, there's all these laws, you better watch out, you're not touch anything, right? And you better not do anything. And that's not at least what I'm saying. I don't think anybody here is saying that, right? That we're trying to tell you that there's a way to get you green, and that's what we do. There's some things that you're going to bring to us and we're going to say, that's just red. There's no way you're going to turn it around unless you go change the law with Congress, right?
Right. Don't get there yet.
You can't get there yet. But we can say, don't do it this way, but if you tweak it a little bit, we think you can get there, right? We're willing to be creative with you. And so there's a lot of things you can do, and there are a lot of pillars, as Carlos said earlier. There's a lot of laws here. What we're doing here with cryptocurrencies that allow for smart transactions to move assets around and smart contracts on commodities, tokenizing pork bellies, right, for the emerging markets. There's just a lot of moving parts and pieces where the laws do apply, and some of these laws have been around for a very long time and there's strict penalties. So it's not for the weak of heart. Like if you've got a good idea, go pursue it. If you don't have $10,000 to invest in your business and go figure out some of the basic legal issues, you better go borrow from your friends and family, because if you just go do it on your own and it touches finance or commodities or something else, I mean, it's kind of like, you'll know when you see it, right? Like if it's, hey, I'm just doing the Ujo music thing, right? Like I've connected, there's royalties to get to the artist and all, like go do that all day long. That's what startups have been doing. Great, it's kind of embedded with, but you don't have to do a lot of big investment. But if you're dealing with commodities, securities, moving money internationally, okay, those are the types of things where you just gotta go look at it.
Yeah.
And it's not simple, but a lot of firms have figured out some primers to give you at a low cost, so you can steer in the right direction, go develop the right way.
Yeah, I would echo Dax. We're not here to say, no, this is way too risky. It has its risk, no question, but it is the future. It's happening. The regulatory environment is trying to catch up. There's too much going on that's too good, that's disintermediated and reconstructed. There are political interests that are putting the brakes on this. There are large financial interests that are putting the brakes on this, and those are just the realities. That's what we're dealing with. There are laws. There are plenty of laws, and they're designed to make sure that if something comes around that doesn't fit, we better shut it down until you can figure it out.
We've got time for like 2 questions left. So Eric in the back.
So it seems to me like for example, the DAO attacker, like he's in the wind now. Like he just generated some private keys for himself, like by rolling a pair of dice. So like his identity is just gone. So that seems like the exact situation where this regulatory environment fails. So I'm wondering if you guys think that there's any way that anything to provide any efficiency for this kind of situation where the dude is just in the wind. Whoever it is, they're just in the wind, you know?
So, what would the question be?
Is the question how to find him?
How to find him?
Is there saying, is
Or what
it
the
What
options
other
would be?
regulatory recourse?
If you go back in time and you look at things like some of the first things that happened to banks, some of the phishing schemes that are going on today actually happened in banks. You used to have the old bank examiner problem. Person would stand outside, wait for an elderly person to come, say, did we think the teller's stealing money? Okay, so these scams, often the first time that they happen, whether it was in the real world with banking, ATMs, the first time somebody finds a way to exploit it, we rarely catch them. Rarely catch them. What we do is we put a mechanism in place that exact thing can't happen a second time. And that's probably the best that can come out of this.
Well, Mt. Gox, right? Mt. Gox happened, and all the other exchanges said we're going to build it differently. And multi-sig came out of that, and audits, peer audits to figure out, what are the holdings. The things you do evolve over time.
But in reality, the first person to think of a very good crime often does probably get away.
Yeah, so my question is around consortium blockchains. Is there anything in particular from a legal standpoint, if you have a fixed set of participants and they're corporations across international boundaries, but they want to use a consortium blockchain to actually transact business?
Can they do that? What's the question?
Are there anything in particular that I would need to know from a contractual perspective if I wanted to, rather than a normal integration of those national companies trading together over normal EDI or something like that, I want to use blockchain instead.
So you're just using the blockchain platform in place of paper contracts?
Or traditional electronic integration formats like EDI.
I think it's again, it's a function of what it is you're looking to do specifically.
Well, I mean, we follow transactions, right? And so if this consortium is dealing, if it's a network that goes across multiple jurisdictions, you actually have to look at the segment and figure out, in that jurisdiction, if money's flowing or to contract, whatever it is, how is that regulated under Singapore law versus US law, right? So these international models are just more complicated. If you're just internationally based and you only have some international customers in certain jurisdictions, it's easier than operating in the US, for instance, right? But a lot of people want to say they're going to set up someplace internationally, and then they think they can sell in the United States, and that doesn't work. So
It sounds like you have a very specific application in mind, and I don't think us up here are equipped to issue a very specific thing, but you're asking the right question of, I have a specific thing that I want to do, and I need to have somebody look at it to make sure, because we don't want to leave with the impression that you shouldn't be doing these things. These are great, huge steps forward that are being made, but you won't necessarily know that you have a problem unless you ask somebody who can identify that you've got a problem. And that person is likely to tell you, you're 96% okay, but this 4% is going to cause a major problem unless you do something about it. So you need to change this one thing, and then everything will be kosher.
Because my boss is asking, like, look, we have all these expensive electronic interactions that are set up for transacting business, right? Around old school technologies like EDI and that sort of thing. He wants to, can I use blockchain instead and lower my costs and get rid of all this stuff? He's
So
asking me
I was
about
just thinking, if
how-
you've got a group of companies and they're just interacting transactions between them, it kind of sounds like these are just, they're not.
Replacing existing old
They're
school.
not talking about creating something as a consortium that's selling out to the public or bringing, these are intercompany contracts.
It's literally replacing existing trading partner integrations that are electronic, using older technologies with blockchain.
So going back to, the point that's been raised continuously, that set of intercompany transactions would probably, depending again on what specifically those interactions were, may or may not be regulated. If it didn't involve securities, selling securities to somebody or to each other, or money transfers between each other, if it were goods and services, that they were just using the blockchain to say, we're going to pay for, your janitorial service, it's be ridiculous, but the blockchain's going to govern how you get, the payment process. No, you're not implicating securities
So
laws.
I'm thinking things like global trade finance, right, supply chain management. Blockchains are beautiful for this, right? And they are going to be replacing EDI and all sorts, and SWIFT and all sorts of other models, because blockchains are great for time stamping information into a blockchain and making sure it's traceable and immutable, and you can act on it. You can have oracles that kick, it's a trigger to kick some delivery out of a payment. And I think for a while you're gonna see kind of parallel ledgers running with whatever systems you got today, right? But we're only scratching the surface on innovation, right? Like we've gone from kind of movement of money to now looking at like back office settlements, securities and commodities and other uses in the financial services space. But we've got so many other sectors that we can go work implement a blockchain for our contracts through, right? And so there's an enormous amount of innovation going on right now, a lot of brain power going into these things. So I think you're doing exactly the right thing, to go, can I replace this whole legacy system with something here that's better, and maybe it's distributed, it's open source, it's cheaper, it's presumably more secure, because more people are watching it, right?
I would just say with permission ledgers, there are several folks who are investigating unique legal issues related to permission ledgers. And in particular, if you're dealing with consortium, I don't know what you mean by consortium, but there's a fellow at the New York Business School who is looking at consortium uses of permission ledgers and interaction with antitrust laws. So you might look to the New York Business School to see his writings on that, if that's in the realm, because I don't know what you're talking about. But there are people looking at permissioned ledgers and legal issues regarding those in particular. And I can give you
So that is our last question we have. The library's closing, so we have to get out of here. So if everybody would want to meet up, we've got a place down here down the road.